Today, we are going to talk about the implementation mechanism and procedure under the ICESCR. The system of supervision devised for the ICESCR differs from that of the ICCPR principally in so far as it does not possess the equivalent of the optional protocol to the ICCPR for the purpose of receiving individual petitions. It was considered during the drafting of the covenant that the progressive nature by which the rights were to be implemented rendered it impossible for individual complaints to be entertained. It would not be possible to speak of violations in a context where all that was being considered was the sufficiency of legislative and administrative programs. Accordingly, the ICESCR was left with the reporting system as a means of supervision to be undertaken not by an expert committee like the Human Rights Committee, but by the Economic and Social Council, that is ECOSOC, as one of the political organs of the United Nations. According to Articles 16 and 17 of the Covenant, states are required to submit reports at intervals to be defined by ECOSOC on the measures which they have adopted and the progress made in achieving observance of the rights in the Covenant. The reports are to be sent to the UN Secretary General, who is required to transmit them to ECOSOC for consideration. ECOSOC may in turn transmit the state reports to the Commission on Human Rights for study and general recommendations or for information, and may invite the UN specialized agencies which are to be sent copies of the relevant parts of the state reports to report to it on the progress made in achieving observance of the rights. Finally, ECOSOC may from time to time submit reports and recommendations of a general nature to the General Assembly and may bring to the attention of the other UN organs and specialized agencies any matters that may assist such bodies in deciding on the advisability of international measures likely to contribute to the effective progressive implementation of the Covenant. The system envisaged in Part 4 of the Covenant does not clearly identify which body has central responsibility for supervision, that is ECOSOC or the Commission on Human Rights, nor does it stipulate the precise content of the reports to be submitted by state parties or the nature of the scrutiny to be undertaken by the UN bodies mentioned. What is clear under Part 4 is that nobody has the ability to interpret the Covenant in a manner that binds states parties, and the states are merely under an obligation to submit reports at periodic intervals. Any further participation in the supervisory process is entirely voluntary. It was not expected that ECOSOC would assess the state reports or evaluate state performance with respect to the implementation of obligations under the Covenant. This, however, is not how the supervision system has ultimately developed. The CESCR is composed of 18 experts, sitting in an independent capacity chosen with due regard to equitable geographical distribution. It officially meets in Geneva each year for a single 3-week session, although additional sessions are frequently arranged. As of May 1998, the committee has held 18 sessions. It was created by ICESCR and its mandate is merely to assist ICESCR in the consideration of state reports. Although it operates in a manner broadly similar to that of other human rights treaty bodies, it has not been hampered by the constraints of a detailed constitutional instrument and has therefore been able to develop its working methods quickly and flexibly. The ICCPR and the ICESCR have elaborated 2 types of implementation mechanism for 2 broad categories of human rights. The Economic and Social Council, that is ICESCR, was the key organ for the progressive implementation of economic, social and cultural rights till 1985. And Human Rights Committee is the main instrument for implementation of civil and political rights. The decision to divide the international human rights instruments into 2 separate covenants was not a decision to have 2 entirely different documents. As a matter of fact, the couple of rights are common in both the covenants, namely the right of self-determination, that is Article 1 of ICCPR and ICESCR, prohibit discrimination, that is Article 2, Clause 1 of ICCPR and Article 2, Clause 2 of the ICESCR, and protect the right to join trade unions, that is Article 22 of ICCPR and Article 8 of ICESCR. However, there are rights which are exclusively dealt in both the covenants. Those rights are stated in a specific form and subject to implementation independently from each other. ICESCR laid down the implementation procedures that were to be followed by the state parties. It created 3 stages, biennial reporting process with a cycle of 6 years. In 1981 and 1982, ICESCR modified its composition, organization and administrative arrangements. This resulted finally in the establishment of the Committee on Economic, Social and Cultural Rights, which composed of 18 members elected in their personal capacities on the basis of an equitable geographical distribution. The committee is parallel to supervisory body available under the ICCPR, the HRC in many respects. The committee is subsidiary of ICESCR and therefore subject to rules of procedure of the ICESCR. Again, regarding the nature of obligation under ICESCR, it is different from ICCPR in its express recognition because the rights it guarantees may take more time to realize than the rights guaranteed by the ICCPR. A 3-part typology of duties has been developed which places legal obligation to fully realize each right in the ICESCR into 3 separate duties: to respect, to protect and to fulfill. Achievement of all of these layers of duties arising from a particular right amounts to full realization of that right. However, the fundamental obligation in the ICESCR is for the states parties to take steps towards realizing the rights enumerated in the ICESCR. The state must act to adopt measures aimed at achieving full realization of the rights covered. In addition to the state parties, some UN specialized agencies like ILO, UNESCO, WHO, FAO, UNHCHR work for the implementation of the principles of ICESCR and provides recommendations and prepare programs for the same. India ratified the two covenants on civil and political rights and on the economic, social and cultural rights with certain reservations. Thus, India has voluntarily accepted the ideals and values contained in the UDHR and also in these two covenants. In this regard, Dr. S. Subramaniam opines that all ratifying member states, including the Republic of India, have accepted the values propounded in these two covenants and are duly bound to bring their national policies and procedures in line with these covenants as required under international law and treaty. After all the discussions we had, we can conclude that besides all this, the preamble of the Indian Constitution declares India a sovereign, socialist, secular, democratic republic and sets out main objectives of the Constitution to secure justice for all citizens, social, economic and political. The Indian Constitution envisages a democracy which ensures freedom under the law and the dignity of the individual. Part 3 of the Constitution guarantees the fundamental rights to the individual and Part 4 sets out the directive principles of state policy which gives direction to the state to provide economic and social rights to its people in specific matters. It is clear from the above discussions that the economic, social and cultural rights are no less important than fundamental rights in the constitutional scheme of our country. They are enforceable when they are projected as supplying the content of a fundamental rights, but not just by themselves. The judiciary will not be fettered by any apparent injunction in the Constitution against non-enforceability of the directive principles of state policy. It will, on the other hand, pin the state to its obligations towards the citizens by referring to the directive principles of state policy. Thank you.